The jury has returned verdicts of guilty against the defendant Daniel Groves as to counts 2 through 11, and returned verdicts of guilty as the defendant Jessica Groves on counts 1 through 11 as charged. I'd like to hear from counsel at this point their positions on the doctrine of merger, as to their positions as to any of these offenses being allied offenses of similar import. Mr. Tiemann, I'm going to discuss both defendants at the same time here, so the verdicts are a little different. They're similar enough. I believe we can do that.
Certainly, Your Honor.
What's the state's position on merger?
Well, Your Honor, with regard to aggravated murder and murder, the state, which would apply to Jessica Groves' case, the state would concede that murder would merge into count 1, aggravated murder, as well as count 11, which we have as the last injuries, the non-healing fractures. Count 11 would merge into count 2 for the felonious assault and count 2 murder. Therefore, that would also merge into count 1. For the purposes of sentencing on Ms. Groves, we would elect to go with count 1, aggravated murder, for sentencing purposes. State of Ohio would submit that count 3, the kidnapping, and count 6, the interference with custody, would merge together. They would not merge with any other count. We would elect to proceed with count 3 on sentencing for that. And if I might add, Your Honor, that brings into account potentially Reagan-Tokes, which became effective on March 22nd of 2019. The allegations as to the date of the kidnapping transverse, for lack of a better term, the effective date. For the purposes of sentencing, the state of Ohio is willing to concede that and narrow that down, that it would be pre-Reagan-Tokes sentencing. For the purposes of sentencing, Your Honor, I believe that leaves counts 8, 9, and 10. Count 8, we have argued that as the first serious physical harm, being the healing rib fractures. Count 9 as the skull fracture with signs of healing. And count 10 as the bruising to the right side of baby Dylan's abdomen. In as much as we can't pinpoint the bruising as a separate event, we would concede that that would merge for the purposes of sentencing as well. And frankly, I would submit we could merge it with count 8 or 9, but count 8 makes sense to me based on the evidence before the court.
That was 8 and 10?
Yes, Your Honor. The other counts, tampering with evidence, count 5, and gross abuse of a corpse, count 7. The state of Ohio would argue those two counts do not merger. We would submit that there were dissimilar import and separate animus. We have the tampering with the evidence that the state has argued was the wrapping of Dylan's body in the multiple layers of the cocoon, so to speak. In count 7, we would submit that that would be for the dropping and leaving the child's body in the well, or that the child, there's evidence that his body was left around the home for a couple days. So the state of Ohio would argue those should not merge for sentencing. Thank you, Your Honor.
What's the state's position as to count 4, child endangering?
Your Honor, State of Ohio would submit as a matter of public policy and case law that count 4 child endangering does not merge.
Relying on State v. Brown on that from the Ohio Supreme Court.
Well, factually, evidence-wise, the repeated exposure to dangers to the child through the case, as well as the continued failure to act or call 911. And for case law, yes, Your Honor, the state would rely on State v. Brown.
Thank you, Mr. Tiemann. Ms. Scott, you want to be heard as, and is your position the same as to Daniel Groves on these multiple counts?
With one exception, Your Honor.
The exception of the aggravated murder charge?
Yes, Your Honor.
Ms. Scott, you want to be heard as the issue of merger?
Yes, Your Honor. I do believe that I would agree with the majority of what Mr. Tiemann said in regards to 2 of the counts of felonious assault, if I understood all of this correctly. 2 of the counts of felonious assault will merge. In regards to the murder case, the kidnapping is going to merge with the interference of custody case. What I would disagree with, Your Honor, is that the tampering of evidence and the gross abuse of corpse, I believe it's the state's position that those would not merge. But what I would argue, Your Honor, is that they would merge at this time, that they were one continuous act with one continuous animus that was presented. I know that the state has pointed out and said that they're considering the wrapping of the body as tampering with evidence, as well as, and the gross abuse of corpse would be the well left in the home or the baby left in the home for a couple of days or placed in the well. In regards to tampering with evidence, there has to be knowledge that there will be an investigation that's given rise in regards to certain actions. Just because a crime is committed, that doesn't necessarily give rise to an investigation. There was...
There's pretty ample evidence of that, though, at least as far as Children's Services trying to find this child.
Well, it depends on the date of when you consider the act happening, Your Honor. I believe that would be a clear distinction if we're in what the court will take into consideration. If the baby passed away on March 28th, as my client purports and as Groves purports, Children's Services saw the child that day.
The jury's verdict would sort of seem to believe that the jury didn't necessarily believe that, though, wouldn't it?
But they were not asked that question directly, and they were not asked to make that finding specifically, Your Honor. So I don't know what was part of their conclusion, was not part of their conclusion. They were not asked to make a special finding in regards to that.
We can presume that he followed the court's instructions, though, can't we?
But I do not believe that the court instructed them to make a finding as to when the body was presumed, or when baby Dylan passed away. I do not believe they were asked to follow that. I do not believe that was anywhere in any of the instructions. So, based on what was purported by my client, Mr. Groves, as well as Jessica Groves, is that baby Dylan passed away on March 28th. That was the same day that Children's Services saw the child at that point in time. They had not given any rise to an investigation being brought forth. I believe that was probably either many days later or even weeks later when that happened. And I do not believe that there was any evidence or testimony that actually locked in the date of death that was presented by the state. So I believe that the majority of the evidence that was presented would have been that the date would have been happened on or around March 28th. And even Patricia Kraft had the firm belief that that baby passed away right after that. So there would have been no investigation at foot. So there would have been no tampering with evidence that could be found in regards to that, wrapping the body up in the various forms of plastic. So we would actually advocate then the tampering with evidence was one continuous act in wrapping up the body, placing him in the crates, and then placing him in the well, or whether or not the court found that the body was left in the home for a couple of days. It was one continuous act, one continuous animus, and not a separate animus, so we would advocate that those would merge as well.
Thank you, Ms. Scott.
Thank
Mr.
you, Your Honor.
Stratton.
Your Honor, I just want to clarify, count 10, was that merging into count 8, or was that merging into the murder charge?
I believe the state had argued that it would merge, or conceded it would merge into count 8.
Yes, I think Ms. Scott said it merged into the, if I'm mistaken.
I believe the state had, I thought she was referenced count 11. The state had, I believe, conceded would merge with the felonious assault, as felonious assault as being the predicate offense for the murder.
Yes.
And the murder, certainly the only charge Mr. Groves is convicted of, the most serious charge that Mr. Groves is convicted of.
Your Honor, we concede the majority of the merger issues. Again, we concur with Ms. Scott about the tampering and the gross abuse of corpse. And we just ask that you make a ruling based upon her argument.
The court's heard the arguments of counsel as...
Your Honor, if I may, I apologize for interrupting. We would, as to Daniel Groves, and I may have already said it, we would elect to, as opposed to count 11, we would elect to proceed on count 2 for sentencing purposes.
I thought you'd said that, but perhaps you hadn't. I will note the state's elections as to both Jessica Groves and Daniel Groves.
Right. Count 1 is to Jessica Groves, right?
Yes.
Okay.
As to the defendant, Jessica Groves, I am going to find that count 2 merges with count 1 for purposes of sentencing. State has, as does count 11. I will find that the state has elected to proceed with sentencing as to aggravated murder, count 1. As to count 3 and count 6, I will find that those are also allied offenses of similar import and merge for purposes of sentencing. State has elected to proceed as to count 3 on Jessica Groves. As to count 4, I'm going to find that that does not merge. Given the testimony, I'm going to find that that is an offense of dissimilar import and does not merge for purposes of sentencing. Count 7 and count 5, 5 being tampering with evidence, 7 being gross abuse of corpse. The court has heard testimony of different acts that would give rise to the conviction of each of those charges. The state has argued that here today. In certain respects, conduct that would, separate conduct that would justify sentencing on both of those. I'm further going to find that we look at the doctrine of merger, we look at the issue of multiple sentences for the same crime. I'm going to find that the Ohio General Assembly has created a specific statute of gross abuse of corpse, and I am going to find that by doing that, the General Assembly has specifically indicated that that would be a crime in and of itself, and I am not going to merge those offenses. As to the charges of felonious assault, I've already found that count 11 would merge with the murder and aggravated murder charges. I'm going to find that count 8 and count 10, both charge felonious assault, are allied offenses of similar import and would merge for purposes of sentencing. As the defendant Daniel Groves, I am going to find that count 11 would merge with count 2 of the indictment, being the predicate offense and from which the murder is based upon, and the state has elected to proceed with count 2. As to count 3 of the indictment, I'm going to find that count 6 and count 3 would merge as allied offenses of similar import, and the state has elected to proceed with count 3, kidnapping, for purposes of sentencing. I'm going to find that child endangering does not merge, and I will further find that count 5 and count 7 does not merge for purposes of sentencing for the same rationale as I had indicated earlier. I would further find that count 10 of the indictment is also an allied offense of similar import. It's, from the testimony I heard, committed with the same conduct, the injuries, and the state has elected to proceed with count 8. Are the parties ready to proceed with sentencing in this matter?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Heeman, do you want to speak, or does the victim representative wish to speak first?
Your Honor,
Or does she wish to speak?
Your Honor, we would ask that Andrew Bowling be permitted to speak. I have some brief comments, and I'd refer to her after that.
Okay. You're going to speak first, aren't you, Mr. Teeman?
Yeah, I'll speak briefly.
Ma'am, just have a seat. We'll have you come forward here in just a minute.
Your Honor, as the court is well aware, this is a case that's been very, very rough for the community, extremely impactful, and a terrible, horrible event. Being a murder charge for Mr. Groves and aggravated murder for Jessica Groves, the court's well aware of the different standards that apply, but I would direct the court's attention to some of the guidelines that we use in other felony sentencing matters out of 2929.12. I would submit that this is the most serious kinds of crimes that we see with the loss of an infant child through such a horrible means. The victim's age certainly played part in the child's helplessness. Be a victim to the people that should have protected him the most. That relationship, unfortunately, facilitated the offense. Certainly the offenders were parents. The victim was their child. The evidence is unclear if it was committed in the vicinity of another child, but certainly this event is also a tragedy to Daniel Groves Jr. I'd like to think that something positive will come out of this. We pray that it will. There's, to a certain extent, the community has been spurred to act. But as for these two, the state of Ohio, when it comes to Jessica Groves, the mother of this child, the woman that gave birth to this child, the state of Ohio would recommend we receive a sentence of life without parole for the heinous act she has committed. I'd like the court to consider the pain the child was put through in its last days on this earth. As to Mr. Groves, certainly the sentence for a murder charge is 15 to life, but we would ask the court to run consecutive sentences for his failure to act again and again and again in this matter. And for that, we'd recommend a significant sentence before he is eligible for parole. Thank you, Your Honor.
Thank you, Mr. Teeman. Ms. Bowling, I believe you wanted to give a victim impact statement as the victim representative in this matter. If you'll have her step at the podium here.
Right here, man. Just face this way.
Mm-hmm.
From the moment I picked up Dylan from the hospital, I loved him. I am speaking for Dylan right now. I didn't get to have a voice. My life was cut too short. But my life will have a huge impact. My foster mom will make sure I help and save and protect other babies. Today is my first birthday. I didn't get to have my party, no cake, ice cream, I didn't get showered with gifts, but I did get justice today. And right now, I'm sitting on Jesus' lap. The angels have me now. My chance to have an earthly life was taken way too soon. No chance to learn to ride a bike, to learn to fish or play baseball. No chance to run and play on the playground or to meet my friends and family. I was perfect. I could have been anything. A preacher, a doctor, a lawyer. But now my purpose is to help save others. I will watch my life protect babies on earth, and I will rejoice when laws are changed. I had a little footprint here on earth, but my impact was anything but small. My impact on this earth is huge, and I look forward to the day that my foster mommy holds me again.
Thank you, ma'am. Before I proceed with the defense counsel's statement and the defendant's allocution, earlier during, we were going over merger, the state had conceded that the Reagan-Tokes enhancements giving the date range of these particular offenses would not apply. I'm assuming that the defense counsel also agrees with that.
Yes, Your Honor.
Yes, Your Honor.
Ms. Scott, anything you would like to say on behalf of your client?
Would you like me to remain here at the table or step to the podium, Your Honor?
You're fine there at the table if you'd like.
That's fine. I have a voice I think would carry far enough. Your Honor, as I have stated throughout these entire proceedings, this is not a topic any of us want to address. This is not a topic that any of us want to talk about. I would ask that the court will take into consideration my client's lack of criminal record, lack of felony record. I would ask that the court would take into consideration what he chose to own and what he chose to disown and what the jury found here today. I believe that my client has been impacted by this. I know that the community has been impacted by this, and I know that the court intends to impose a heavy sentence in this matter, but I would ask that the court would be reasonable, that the court would not provide maximum sentences in all of these matters and not also run them all consecutively to each other. I do not know that my client's prior criminal record would warrant that, or that his actions warrant that. And I would hope that the court would take all of that into consideration when making and rendering a sentence here today. Thank you.
Thank you, Ms. Scott. Mr. Daniel Groves, is there anything you'd like to say before I impose sentence?
No, sir.
Mr. Stratton, anything you'd like to say on behalf of your client?
Yes, Your Honor. This has been a difficult matter for this entire community. It's been shared with a lot of people. Jessica took responsibility. And I just ask the court to consider that in sentencing.
Thank you, Mr. Stratton. Ms. Jessica Groves, anything you would like to say before I impose sentence?
I'm just so very sorry. No matter what you do to me, you can never do what I will do with myself. What I have to live with for the rest of my life, knowing that I did this to my child. I failed as a mother. I'm sorry.
Anything else you'd like to say? You can be seated. This matter comes before this court this 10th day, January 2020, which defendant's sentencing hearing is being held pursuant to Revised Code Section 2929.19. Now, Mr. Groves, certainly you'll have a right to appeal any sentence I give you in this matter. Do you have funds to hire a lawyer to represent you on this any appeal that you choose to pursue? Ms. Scott, are you willing to accept the appointment for the purposes of that appeal?
Your Honor, if I do accept that appointment for appeal, that does cause my client to waive certain arguments that he may have. Could I refrain from answering that question at this time until after consultation with my client off the record?
I will need
so
you.
He would be fully advised of that?
I will need you to advise the court staff no later than Monday morning.
I can do that, Your Honor.
Sir, I will need you to fill out another financial disclosure form so I can appoint counsel to represent you. Now, Ms. Jessica Groves, likewise, you have the right to appeal any of the decisions I've made in this case and any sentence that I would give you in this matter. Do you have the funds to hire a lawyer to represent you in that appeal?
No, sir, I don't.
All right. Mr. Stratton, would you be willing to accept the appointment for purposes of pursuing that appeal?
Your Honor, it's always been my policy to not work on the appeals of my trials, so I ask that you appoint other counsel for that matter.
Thank you, Mr. Stratton. I would ask, I will appoint counsel to represent Ms. Groves following sentencing. Ms. Scott, Mr. Stratton, I would ask that both of you consult with your clients and file any appropriate notice of appeal, even if you choose not to remain on the case.
Yes.
And I will appoint counsel to pursue that appeal. Defendants in this matter have been afforded all rights pursuant to Criminal Rule 32. This court has considered the record, the oral statements made, the victim impact statement presented in this matter, as well as the purposes of sentencing as found in Revised Code Section 29.11a to punish the offender, protect the public from future crime by the offender or others, and using the minimum sanctions this court determines accomplishes those purposes without imposing unnecessary burden on state and local government resources. This court has also considered the allocution of both defendants of Ms. Groves as she's provided it here in court today. The court has also considered the principles of sentencing as found in Section 29.11a, b, and c, specifically the need for incapacitation, deterrence, rehabilitation, and restitution, as well as being commensurate with and not demeaning to the seriousness of the offender's conduct, its impact on the victim, and the consistency of sentences for similar crimes by similar offenders. This court has considered and balanced those serious and recidivism factors as found in Section 29.12, b, c, d, and e, and also considered those factors as found in the Revised Code Section 29.13b. This court is also going to find that consecutive sentences are necessary to protect the public and from future crime, and to punish each offender and not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. The court will further find that one or more of the multiple offenses was committed as part of one or more courses of conduct, and the harm caused by two or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of the course of conduct adequately reflects the seriousness of the offender's conduct. This court will further find as to the defendant Daniel Groves, pursuant to Revised Code Section 29.12b, specifically, this court is going to find that the injury was exacerbated by the victim's physical condition or age. Also going to find that the victim suffered serious physical harm as a result of the crimes. This court's further going to find that Mr. Groves' relationship with the victim facilitated this offense, and I'm also going to find that he was the parent, custodian, or person in place of the parent or custodian at the time the offense was committed. I'm also going to find that the defendant in this matter, Daniel Groves, does have a criminal history, although that criminal history consists of only a misdemeanor conviction. And I will find that there's been no proof or evidence brought forward of any felony convictions. I will further find that the offender shows a pattern of alcohol and drug use related to this offense and does not acknowledge or refuses treatment. I'm also going to find that he's shown no genuine remorse. As to the defendant Jessica Groves, as to those factors in 29.12, I will likewise find that the injury was exacerbated by the victim's physical condition and age. The victim suffered serious physical harm as a result of the crime, that the offender's relationship with the victim facilitated the offense, and that this is an offense where she committed this crime on her child as the parent, custodian, person in loco parentis. Going to further find that she has shown a pattern of alcohol or drug use related to this offense and does not acknowledge or has refused treatment. I'm also going to find, despite her allocution here today, that through these proceedings she's shown no genuine remorse. I will find that she has no prior criminal convictions. Defendant Daniel Groves, will you please stand? Sir, as to count 2 of the indictment, you have been found guilty of the charge of murder. I will sentence you to the prescribed term of imprisonment for that offense of 15 years to life, in the custody of Ohio Department of Rehabilitation and Corrections. As to count 3 of the indictment, you are convicted of a charge of kidnapping, a felony of the first degree. You have been found guilty by the jury. I am going to sentence you to a term of imprisonment of 10 years in the custody of Ohio Department of Rehabilitation and Corrections. As to count 4 of the indictment, charged child endangering, a felony of the third degree, I will sentence you to a 36-month term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 5 of the indictment, charged tampering with evidence, a felony of the third degree, I'm going to sentence you to a 36-month term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 7 of the indictment, charged gross abuse of corpse, a felony of the fifth degree, I'm going to sentence you to a 12-month term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 8 of the indictment, you are convicted of charged felonious assault, a felony of the second degree. I'm going to sentence you to an 8-year term in the custody of Ohio Department of Rehabilitation and Corrections. And as to count 9 of the indictment, I am going to sentence you to an 8-year term in the custody of Ohio Department of Rehabilitation and Corrections. I am going to order the sentence in count 5, tampering with evidence, and count 7 to run concurrently with each other. It would be my intention, by imposing this sentence, to impose a term of 47 years to life in the custody of Ohio Department of Rehabilitation and Corrections. And we'll give you credit for the 213 days you've served in the county jail while awaiting trial. You can be seated. Defendant Jessica Groves, will you please stand? Ma'am, you stand convicted of the charge of aggravated murder. It will be the sentence of this court that you be sentenced to a term of imprisonment of life without the possibility of parole as to count 1 of the indictment. As to count 3 of the indictment, charged kidnapping, a felony of the first degree, I will sentence you to a 10-year term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 4 of the indictment, I am going to sentence you to a 36-month term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 5 of the indictment, charged tampering with evidence, I am going to sentence you to a 36-month term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 7 of the indictment, charged gross abuse of corpse, I am going to sentence you to a 12-month term in the custody of the Ohio Department of Rehabilitation and Corrections. As to count 8 of the indictment, I will sentence you to an 8-year term in the custody of the Ohio Department of Rehabilitation and Corrections. As to count 9 of the indictment, also charged felonious assault, I will sentence you to an 8-year term in the custody of Ohio Department of Rehabilitation and Corrections. As to count 5 and count 7, I will order those sentences to run concurrently with each other. However, pursuant to my earlier findings, I will order the remaining charges to run consecutive to each other. It would be my intention to impose a sentence of life without the possibility of parole plus an additional 32 years as part of this sentence. You can be seated. I will also give you credit for the 213 days that you've served in the county jail while awaiting trial in this matter. I am going to order that both of you pay the cost of prosecution in this matter. I am going to order, at least as certainly to Mr. Groves, to a portion of his sentence, possibly to Mrs. Groves as to part of her sentence. You may be able to earn days of credit towards this sentence pursuant to Revised Code Section 2967.193. However, those days of credit are not automatic and do have to be earned pursuant to the statute. I'm going to order you to both pay the cost of prosecution in this matter. I am going to order the Sheriff's Office to destroy any contraband seized in this matter once all appeals and post-conviction proceedings are complete. Anything further, Mr. Tiemann?
No, Your Honor, thank you.
Ms. Scott, anything further?
Not at this time, Your Honor. Thank you.
Mr. Stratton?
No, Your Honor, thank you.
Mr. Daniel Groves and Ms. Jessica Groves, at this time I am going to remand you to the custody of the Sheriff for transport and conveyance to the Ohio Department of Rehabilitation and Corrections. Court is adjourned.